Welcome everyone. Today's topic is the doctrine of separate legal entity. So let's just start with the concept and then we are understanding the landmark case for the same. The doctrine of separate entity really asked one question: whether the company and its member are two different person or not. We are saying that the company is a artificial person, but is it true? Are we really treating the company as a separate person or not? So that's we are going to understand today. And there is a case for the same doctrine, that is the case of Solomon and company. We are going to deal with the facts and then the judgment, what are the judgment and what is finally declared related to this principle, or we can say the doctrine of separate legal entity. So move on. The doctrine states clearly that the company has its own separate entity. The members, the shareholders of the company are different than the company itself. Company in itself is a separate legal identity. So both are two different persons. So if we understand the meaning behind the separate identity, that means we have a right, a person have a right. So we can say the company also have a right. We can own the property, so company can also own the property. So let's start with the concept of this doctrine. The first point in the concept is that the separate legal entity means what? Means the company really exists. Yes, we cannot say there is no company. There is us. We are managing the company. So we are the company. No. We and the company are two different persons. So yes, company does really exist. Now, as the normal person, company can sue another person. Yes, if someone has been doing fraud with company can take that person to the court and demand the justice. And so other person can sue upon the company if company has been doing the wrong. As the normal person, company hold the property, buildings, premises on its own name. If we are the directors, property are not on the director's name, it's on the company's name. So company can hold its property in its own name. And just as the normal person, if company is incurred any loan to the parties, then company is liable for that loan and not any other member, shareholders or the employee of the company. Company itself is liable for that debt. So this is the concept of separate entity. But are we really practicing this entity or not? Are we really implying this doctrine of separate entity in our real life? Well, that question was raised in the Saloman case, and we are going to understand that next. The same question arose in the case of Saloman and company, that whether the company and this Mr. Saloman are two different things, or Mr. Saloman is just merely an agent of the company. Let's start with the facts of the case. Mr. Saloman was a businessman who wants to incorporate a company, and he incorporated the company, transfer his business to the company as per all formalities of the requirement or required act. As you all know, if you want to incorporate a public company, then you required certain number for your members to incorporate a public company. So Mr. Solomon did the same. Mr. Solomon incorporated his company and his family member become the members of the company. So basically what he did, he made his family members his business partner by issuing in equity shares to each one of them. Now, what happened afterwards? Mr. Solomon charged pound 39,000 for their business because the company is purchasing the business of Mr. Solomon. But company couldn't pay in cash full amount, so company issued secured debenture to Mr. Solomon. Now you all know that the secured debenture comes before any other unsecured liability or any debenture. The secured debenture has to come first for a payment or if the company is going for the bankruptcy. But unfortunately, soon after the business incorporated, the shoe industries witnessed a very series of strike. Since the company was in need of more funds, the company borrowed £5,000 from Broadrip. And however, in the end, business failed and became bankrupt. Now, at the end, the amount is going as per the secured debenture to the Mr. Solomon. So now the case come into the picture. The person from whom the company borrowed last money, Broadrip, has filed a suit on a company to demand a payment to them, not to the Mr. Solomon. By arguing that Mr. Solomon is the owner of the company, Mr. Solomon and company are the same. So company should pay the remaining amount to the Broadrip and not to the Mr. Solomon. And the argument win the judge. It means the judge declared and confirmed the argument that yes, payment should be made to the Broadrip and not to the Mr. Solomon. Solomon made an appeal against the order, but unfortunately, the further appeal also confirmed the earlier decisions and demand that the payment should be made to the Broadrip and not to the Mr. Solomon, as merely is an agent of the company. So guys, did you understand what happened here? Once we are saying that company is a legal separate entity, and the other side we are saying that you are just an agent. You cannot demand the payment, which of course we are the secured. The Mr. Solomon is a secured. But there is a lot of confusion and judge are giving the order in favor of Mr. Broadrip. So let's see what higher court says about it. In the year of 2012, the House of Lords says that all the previous judgment is not correct. The House of Lords overturned their judgment and says that the argument of fraud, the argument of agency is not be accepted. And the court declared that the money should be given to the secured debenture. Even in this case, the secured debenture is Mr. Solomon. Mr. Solomon and the company are two different persons. So we cannot say the Solomon isn't merely working as an agent. No, the right should be given to him. And since then, the legislature and the court have been following this principle with the landmark case of Solomon and Solomon Company. So, with this, we are concluding the doctrine of separate legal entity. If you have any questions, please let me know by comments. Thank you.